Welcome, friends. Today we are going to start our discussion on the additional grounds of divorce available to the wife. Friends, as you are aware, we are discussing about the ground of divorce under Hindu Marriage Act. Before starting the today's lecture, I want to summarize the previous lecture. In the last class, we discussed the different grounds of the divorce, where we discussed about the mental unsoundness and mental disorder as a ground of divorce. Be carefully understand that the presence of disease is one thing and impact of disease is another thing. Means mental disorder, psychopathic disorder, arrested mind, incomplete development of mind, such kind of existence of disease per se is not against the provision. But if mental unsoundness affect your societal relationship, then it becomes the ground of divorce. Friends, in the last class we also focus on the venereal disease in communicable form and renounce the world, enter into the religious order, long disappearance, and we also discuss the frustration theory of marriage and frustration theory of divorce under section 13 subsection 1 clause under bracket 1 capital A, where I discuss that there is a decree of judicial separation and restoration of conjugal rights, but there is no cohabitation between the parties. 1 year or more than 1 year time has been lapsed, it provides a ground of the divorce. Friends, please recall the lecture where I discussed with you that fault theory grounds available for husband and wife both. 8 grounds: adultery, cruelty, desertion, conversion, mental unsoundness, venereal disease, and long disappearance, enter into the religious order. 8 grounds are common grounds of the fault theory. Both the husband and wife is entitled to enjoy the grounds, friends. But friends, today I want to focus on the special grounds which is specially available to the wife. On the basis of these grounds, wife may file a petition of divorce, friends. These grounds are not available to the husband because this is exclusively available to the wife. And friends, before starting the lecture, I want to identify the learning objectives of the today's lecture. Friends, the learning objectives of today's lecture includes additional grounds of the divorce available to the wife, bigamy committed by the husband as a ground of divorce available to the wife, husband is guilty of rape, sodomy and bestiality as a ground available to the wife, non-redemption of cohabitation after the degree of maintenance as a ground of divorce available to the wife, and wife rights of repudiation of marriage. So we will understand these 4 points during this lecture, friends. So now I want to focus on the additional grounds of the divorce available to the wife. Section 13 subclass 1 provides various grounds of divorce to the both the parties of marriage. Apart from these grounds, the Hindu Marriage Act 1955 provides more grounds of divorce to the wife. Section 13 subclass 2 provides additional grounds of divorce which is only available to the wife. Friends, originally subsection 2 has only 2 clauses, but in the year 1976 it was amended and 2 more grounds were inserted in section 13 subclass 2. Therefore, total number of grounds as if now is 4, and 4 ground of the divorce which is exclusively available to the wife, friends. Friends, now I want to focus on the statutory provisions related to the grounds available to the wife. As per section 13 subclass 2, a wife may also present a petition for the dissolution of her marriage by a decree of divorce on the ground. First, in a case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, and that any other wife of the husband married before such commencement was alive at the time of solemnization of marriage of petition, friends. This is a pre-act marriage, friends. Suppose a husband already married before the enactment of Hindu Marriage Act, and after the enactment of Hindu Marriage Act, he again want to marry with others and married, then it is the ground of the second wife proceed for the divorce, friends, provided that other wife is alive at the time of presentation of petition. Second class is that the husband has, since the solemnization of marriage, been guilty of rape, sodomy and bestiality. The third is that in the suit under section 18 of Hindu Adoption and Maintenance Act 1956 or in proceeding under section 125 of CRPC or in any other act. Now the provision of maintenance is also given in Bharatiya Nagarik Suraksha Sanhita 2023, friends. Friends, a decree or order, as the case may be, has been passed against the husband awarding maintenance to the wife, notwithstanding that she was living apart, and since the passing of such decree or order, cohabitation between the party has not been resumed for 1 year or upward. The fourth ground is that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years, and she has repudiated the marriage after attaining the age, but before attaining the age of 18 years. She repudiated the marriage. She married before the 15 year and she repudiated the marriage before the attaining the age of 18 years. Friends, this is the literal provision of the grounds available to the wife under the Hindu Marriage Act. These grounds are exclusively available to the wife, friends. Friends, now we can summarize the grounds of divorce available to the wife in 4 broad categories. The first category is, friends, another marriage by the husband before the commencement of the act. Husband is guilty of rape, sodomy and bestiality. Non-redemption of cohabitation after the decree or order of maintenance. And the fourth is option of puberty. These are the grounds. On that basis, wife may proceed for the divorce, friends. So now I want to focus on the second ground. Now I want to focus on the first ground of divorce, friends. Bigamy by the husband, friends. Friends, as you are aware about that, before the commencement of the Hindu Marriage Act, Shastric law permits Hindu to marry more than one wife. Friends, it was more permissive than Muhammadan law that restrict the number of wives up to the 4. But Hindu law, many marriages were allowed that time. This ground is available only if the marriage was solemnized before the commencement of the act. Means, friends, a person already married before the commencement of the act and he married again after the commencement of this act, while first marriage is still exist and wife is living, then this is a ground of divorce which is available to the wife. So friends, at present the practical usability of this section is very minimal, because a person married before the 1955 is extremely rare, friends. Therefore, such provisions cannot have a practical sense nowadays, because for the purpose of the fulfillment of the requirement of this section, husband married before the act, wife is still alive, and he married again, then second wife may proceed for the divorce, friends. Friends, another marriage by the husband. After the commencement of the Hindu Marriage Act under section 5 subclass 1, read with section 11. Now rule is very clear. Neither party has a spouse living at the time of marriage. This is the primary condition. This is known as strict rule of monogamy. If having a spouse, you entering into the new marriage, another marriage, then due to section 11, marriage is considered as void. So therefore, there is no scope of second marriage, friends. Friends, if a man married more than one wife before the commencement of the act, and then each wife has a right to seek divorce from the husband under section 13 subclass 2. It is pertinent to note that wife of the husband was alive at the time of solemnization of marriage of the petitioner. Because if there no wife exists, there is no cause of problem exists, friends. Friends, in the case of Mandul Naganna versus Lakshmi Bai, the Andhra Pradesh High Court held that both the wives simultaneously, or one after the other, or even when the husband had filed a petition for divorce against one wife, the other wife may apply for the divorce against him. And even if one wife dies or has obtained a divorce or divorced, the wife is also entitled to divorce provided the petition was filed before marriage exists. Means, friends, if previous wife alive at the time of presentation of suit or petition, then second wife is entitled for divorce. For example, on 1st March 2025, first wife is alive, second wife file a petition for divorce. She is entitled to file. On 15th March 2025, first wife is now dead. The death of first wife not restricts second wife from obtaining the divorce under this clause. And in this therefore, in these circumstances, husband may have no wife. First wife is already dead and second wife is capable to obtain divorce decree. Friends, now the point is, in this case, the husband may lose both the wife, is still the court is bound to enforce the provision. The petition is barred if no other wife is alive due to death at the time of petition. But after the petition, then the court is bound, friends, to decide the case. The relief of divorce cannot be refused as the plea that second marriage was with the consent of first wife. Such kind of consent is not sufficient, not required, and not treated legal, friends. This ground is not an absolute. Where the petition is presented with undue or unnecessary delay, then court may refuse to provide you locus for this purpose, friends. The burden of proving the existence of prior marriage on her husband, on the wife filing the presentation of petition. This is the first ground. Pre-act marriage is the ground of divorce. Pre-act marriage of the husband is the ground of divorce available to the wife. Wife may proceed for divorce. Now second ground is husband is guilty of rape, sodomy and bestiality under section 12(2)(2). If husband has since the solemnization of marriage been guilty of rape, sodomy and bestiality, then it is a ground to seek the divorce. Wife may seek the divorce on these grounds, friends. Friends, rape is defined under section 63 of Bharatiya Nyaya Sanhita. Earlier section 375 defines the rape. A man commit rape even if he sexually intercourse with his own wife when she is not attained the age of 18 years. This is known as marital intercourse, marital rape. Friends, attempt to commit the offense of rape is not a ground of divorce. It is not necessary that husband should have been convicted of any other these offense. If husband is guilty of rape by any way, then it is a ground of divorce available to the wife for the divorce, friends. Now friends, second ground is sodomy. Sodomy is an unnatural offense which was defined in section 377 of IPC. Now friends, unnatural offense omitted by Bharatiya Nyaya Samhita 2023. There is no such provision there. But friends, for the purpose of matrimonial law, if husband involved in sodomy means unnatural sex, then wife have a right to claim divorce on this ground, friends. Friends, a man may commit sodomy by the wife also, friends. The offense are committed by the husband by having intercourse against the order of nature with a man, woman or animal. Friends, in the case of K.V. Revanna versus Susilamma, Karnataka High Court observed that the mere expression of desire for sodomy is not a ground of divorce. Now the next ground is bestiality, friends. It is also covered under section 377 IPC. All of these crimes under IPC, punishment is provided for them. But for obtaining the decree of divorce, it is not necessary that husband should have also been punished by the criminal court. As per section 23(1)(a) Hindu Marriage Act provides that court will not permit any party to take advantage of his or her own wrong or disability. Friends, the provision is considered discriminatory because rape obviously committed by the male or husband, but sodomy may also be committed by the wife also. So why the provisions of sodomy and bestiality is available only to the wife against the husband. Friends, but now the provision of Article 15 subclass 3, it is justified and therefore such kind of provision is constitutionally valid, friends. Now I want to focus on the third ground, non-resumption of cohabitation after the decree or order of maintenance, friends. This ground of divorce added in the year 1976. The condition is a decree or order of maintenance to the wife under section 18 of Hindu Adoption and Maintenance Act, order of maintenance under CRPC or Bharatiya Nagrik Suraksha Sanhita, and the such decree or order must be passed against the husband to award maintenance to the wife, and cohabitation between the parties has not been resumed for 1 year or upwards. So there has not been any reconciliation between the parties during the period, friends, and therefore it is considered a ground of divorce. Friends, maintenance order has been passed against the husband and there is no cohabitation. Then wife is entitled to proceed divorce on this ground. Now friends, the fourth special ground which is available to the wife is option of puberty, which is mentioned in section 13(1)(4). This ground is also added through the amendment of 1976. This clause confers on a girl the right of repudiation. If the girl is married before she attained the age of 15 years and she repudiate the marriage after attaining the age of 15 years but before attaining the age of 18 years, then C has right to repudiate the marriage on this ground. Point is very simple and clear. Girl must be married before the age of 15 years. She repudiated the marriage after 15 years but before the 18 years. Then she is entitled to present a divorce petition on the ground, and this is right to repudiation. But this provision is bound with condition, and condition is very simple. Marriage must be solemnized before the age of 15 years. She repudiated the marriage after 15 years but before 18 years. The right must be exercised before the attainment of the 18 year of age. Friends, the explanation of this clause provided that this clause applied whether the marriage has solemnized before or after the commencement of Marriage Law Amendment Act 1976. It is immaterial that when your marriage is solemnized. Therefore, the provision is retrospective and prospective. Marriage solemnized before the act also covers under this section, and obviously after the amendment act, if marriage solemnized, also comes under the purview of this. Friends, it is immaterial for the application that this clause whether marriage is consummated or not. Friends, the only requirement is marriage before the age of 15 years and repudiation. Whether marriage was consummated or not, it is not a matter relevant for consideration. Friends, wife have an exclusive right of repudiation. Such rights are not available to the husband, and therefore husband have no right to repudiation. Friends, in the case of Roop Narayan Verma versus Union of India, the court observed that under Article 15 subclass 3, a special provisions for the benefit of women may be enacted, therefore it is not discriminatory and against the husband. In a case of G.Z. Wayne versus Dayal, the repudiation also may be made before the girl has attained the age of 18 years. But the petition of divorce on the ground is maintainable by her after completing the age of 18 years. She may repudiate the marriage after 15 years, but suit is maintainable after 18 years. Therefore, she should wait in between 15 years to 18 years, friends. Friends, decree are more than one ground, friends. It is possible that the petitioner plead more than one grounds and the decree is also passed on more than one ground. Friends, the scholars argued that there is a need of amendment. Now the age of marriage is 18 years. This was inserted in the year 1976 by Marriage Law Amendment Act. That time age of marriage for the bridegroom, for the bride was 15 years. But by the Child Marriage Restraint Act 1978, age was extended from 15 to 18 years. Therefore, right to repudiation of marriage should also be available when the marriage is solemnized before the age of 18 years. Therefore, an amendment is desirable for this regards, friends, because now we have a different kind of provisions where the minimum age of marriage is fixed, friends. Friends, by this discussion, we may think about certain point. Why is there a need to provide a special ground of divorce exclusively for wife? Is the gender specific nature of provision section 13(2) discriminatory against husband or not? Is the 15 year of age for the girl under section 13(2)(4) of the Hindu Marriage Act appropriate in the present time, considering that the minimum legal age of marriage is now 18 years? Friends, by this I want to summarize my today's lecture. Friends, section 13 subclass 2 especially provides special grounds exclusively available to the wife. These grounds exclusively available to the wife. Originally, Act includes two grounds. In the year 1976, by amendment, additional two grounds added in section 13 subclass 2. Now, four grounds exclusively available to the wife. The grounds are: first is pre-act marriage. Husband already married before the act with more than one wife, and friends, then second wife have a right to move a petition under section 13 subclass 2 subclass 1. This is the case of bigamy by the husband. Subclass 2 is if the husband is guilty of rape, sodomy and bestiality, then wife is also entitled to file a case of divorce under section 13 subclass 2. Friends, point is very simple. Rape may be committed by the husband or male, but sodomy and bestiality is unnatural offense, may be committed by the wife also, but there is no such ground available to the husband. The third ground is there is a maintenance order. After the maintenance order, there is no cohabitation between the parties and 1 year and upwards time has been lapsed. On that basis, wife may present the petition and divorce may be granted to the wife, friends. Fourth ground is option of puberty, friends. The law is very simple and clear that if girl married before the age of 15 years, she repudiated the marriage after 15 years but before the 18 years. Then after the completion of 18 years, she is entitled to file a petition for divorce on this ground. But the important point is, friends, in the year 1976, minimum age for the marriage of a girl was 15 years. After 1978, minimum age is 18 years. Therefore, an amendment is desirable in this class. Right to repudiation should be available in the case of when the marriage is solemnized before the age of 18 years. These grounds are the special grounds available to the wife. Friends, by this, now wife have 12 ground of the divorce. Section 13 subclass 1 provides 8 grounds and 4 grounds are available under section 13 subclass 2. The wife may file the petition of divorce on 12 grounds. Husbands are only capable to file divorce only on 8 grounds. These 4 grounds are special but constitutionally valid due to 15 subclass 3 of Constitution. Why? Because special provisions may be made by the Parliament in reference or benefit to the wife. So this is the discussion of today's class. Thank you, friends. Thank you.